Welcome to our first webinar where there's a will, there's a way. So today we've got a mix of clients and guests on the call. And so some of you, I'm sure, are listening to the replay. So I'm just going to briefly introduce myself for those who are new to us. My name's Viola Vanderuyt, and I'm going to be presenting the webinar today, or as I like to think of it, it's a virtual seminar. And behind the scenes, we have some very important people who will be managing your questions and any technology things going on. So that is Annette Kwan and Rachel Jameson. And before we get started, we'll just go through a couple of housekeeping items. The platform we're using today is Microsoft Teams, and it's what we're using at National Bank Financial because it's a very secure video platform. And we're using this same platform when we do video portfolio reviews with clients as well. But today we're in presentation mode, and so we can't see or hear you at all, but we do welcome your questions and your comments, and you can either enter those with your name or you can enter them anonymously. And so there is a question and answer button on your screen in the, I believe it's upper right corner, but please don't hesitate to ask any questions or comments. And if it's a question that I should be answering in the presentation, it'll get published for everyone to see. And if it's something that's a little more personal and maybe should a private message, Annette or Rachel will respond to you. And so today is being recorded. So at the very end, if you think of a friend or family member that would benefit from it, you can share the link that you used to click in here today, and they'll be able to view and listen to the recording as well. One of the other things I just want to make sure is clear, I'm not a lawyer, but I'm going to be presenting concepts, concerns, and information that you can then take to your lawyer to discuss. And certainly we are going to also be presenting some follow-up webinars or videos on some of the topics we'll touch on briefly today that maybe need to be explored in more detail. So with that, let's get going. Now, the focus of today's estate planning webinar is on blended families. And that's because blended families are very common now. The typical family is changing. It's not the picture idyllic from the 1950s that I put up on the screen there. 21% of couples are now common law. 52% of these couples have children. A lot of families are single parent households, and then 2 single parent households become a blended family. We're also seeing more families with same-sex and multi-generations as well. On that multi-generation note, I'm going to tell a really bad joke, but it illustrates financial planning situation. Dan knew he was going to inherit a fortune when his sickly father died. He decided that he needed to be with his dream woman to really enjoy it. So one evening he went to a singles bar. Whoops, a daisy, went too far. He went to a singles bar and he spotted the most attractive woman he'd ever seen. So he said, you know, I may look like just an ordinary man, but in a month or two, my father's going to die and I'm going to inherit $20 million. Impressed, the woman went home with him that evening. And 3 days later, she became his stepmother. So when it comes to estate planning, there's a lot of different family situations. So as I say, it was a bad joke. But what's more important today is, you know, have you given some thought to how you want your estate to be divided when you pass away? So you really need to give some thought to a lot of the different issues that are going to happen. And the first thing we're going to take a look at is what happens if you pass away without a will. And, you know, we often do see this, that people just aren't sure what they want, so they just don't make a will at all. Or maybe there's some superstition or something going on. But you do need to know what's going to happen if you pass away in British Columbia without a will. Now, every province is different because Every province is governed by their own legislation when it comes to wills and beneficiaries and things. So let's take a look at this then. So if you pass away without a will in BC and you have a spouse, but you have no children, either one of you, you're going to leave 100% to your spouse. Now, if you have children with that same spouse and you passed away without a will, they would get the first 300,000 of your assets that are in just your name, plus the furnishings of the house, and then the kids divide 50% of the rest of it. But if your house was in joint names, then that means that the house goes directly to your spouse if it's joint tenants with rights of survivorship. So this is if there's any assets that aren't joint tenants with rights of survivorship or don't have a beneficiary designation. Now, this is where it starts to get complicated, is if you are a blended family and the spouse you're married to isn't the parent of your children, then your spouse would get the first 150,000 of assets plus the furnishings of the house, and then your children would divide 50% of the rest of the estate, and your spouse, your current spouse, would get 50% of the rest of the estate. Then people wonder, well, what happens if I, pass away without a will and I don't have a spouse? So then if you have children, those children get everything. But if we take it a little further and you passed away without a will, no spouse, no children, then what happens? Well, if you have parents living, then they would get 100% of it. If your parents are passed away and you have some siblings, brothers or sisters, or there's nieces or nephews, then they'd get 100%. But they don't take it any further than that. They don't look any further than your brothers and sisters or nieces and nephews. They don't look for second cousins twice removed. If at that point there isn't those specific family relationships, then it goes to the government. So, question is, if you have a will, and we'll assume that all of you do here have a will, when should you take a look at it? When should you review it and see if you need to make some changes? Well, really, you should be doing that every 3 to 5 years. But also, it's when some major things occur. Obviously, when you first become a blended family and your family situation has changed, or you're separated or divorced, that's a big, obvious one when you need to review your will. But also a change in your financial situation. Maybe you've inherited from your parents or your spouse has, or there's been a retirement. Another thing people sometimes don't think about too is maybe your executor is aging, or maybe your executor has moved away or is no longer really as competent as you would like. So that's another instance where you need to review things. Or vice versa, maybe your children were younger when you made your will and now they're very competent adults and maybe they'd be good executors. So it is something to review from time to time. And another area that we often take a look at is just how well the family gets along. Oftentimes, parents have named, say, both children. They maybe have 2 or 3 children, and they've named them, co-executors. And I'll ask the question, well, do they get along together? Will they be able to agree? And they say, oh yeah, no problem. They get along fine. But then when I ask the further question, what about their spouses? There's generally a bit of a pause. People go quiet and go, oh, right. What we often find is that it's the spouses of your children that can end up causing the issues and the disruptions because they're whispering in the ears of your children. So definitely something to think about. So thinking about what the goal is of estate planning, give some thought to what it means to you. Certainly, it addresses some of the common fears. People have fears about losing capital, fears of taxes and fees, fears of delays in the settlement of their estate. And for a lot of families, I find there's fears of black sheep or what's been termed affluenza. How much do your children, should they really be inheriting? I mean, Bill Gates has decided, along with Warren Buffett, that they want their children to have enough assets to be able to do whatever they'd like, but not so much assets that they wouldn't have to do anything. And another issue for a lot of families too is fear of giving up privacy. And certainly your will is a public document. And so that is something to keep in mind if privacy is an issue for you. Here's some of the main goals of estate planning. And some of these are the things that you think about when your family's younger. So you want to maintain the lifestyle of your spouse and children. I know myself, the first time we had a will done, it's when we had our first child. It's like, oh my gosh, who's going to look after our child if something happens to us? And, that's very common. Another thing is for eliminating debt. A lot of people are concerned about the size of a mortgage or something when they're going to pass away and how that would affect maybe young children that are being left. And certainly the self-employed need to think about the transfer of their business and how their business would survive if they passed away. But another main concern is taxes for the estate and heirs. And this starts to become more and more important as you get older and your assets grow. And you want to ensure that there's liquid assets to pay taxes and still, honor your own wishes. Some people are also looking at ways they can preserve the estate and grow it. But more commonly, we're seeing avoidance of family and legal problems. And as I mentioned, in a blended family, that becomes more and more apparent. What we're also starting to see, and we'll be doing a follow-up seminar on this, or webinar rather, will be support for charities or causes that are really important to you. So these are all very valid goals of estate planning. So with blended families, some of the additional concerns, certainly when the children are younger, is the spousal support obligations or child support obligations. You need to speak with your lawyer as to how those things are going to be affected if you were to pass away. Also as to whether there are old insurance policies that need to stay in place to benefit as the result of your previous separation or divorce, but also insurance policies need to be reviewed to see that the beneficiaries are up to date with what you maybe currently want. So these are definitely big considerations. But what I also find is that there's also a concern for continuity in a family. So let's say you've inherited from your mother, and your intent, and you feel that her intent was that money should eventually go to your children. Well, you need to make sure that the estate is set up in such a way that that's actually what's going to happen and that it's not going to go to your spouse or to your spouse's children. And this is one of the big areas that we see people concerned about. Now, there's other areas of conflict that are going to come up as well. Who did you choose as the executor? Maybe you feel that the child of your spouse is a more appropriate executor for whatever reason than your children. Would that cause some very emotional issues? What about the family home? Did your spouse move into your home? That's the family home that your children consider their legacy. Even things when it comes right down to personal assets, this is where in any family, whether it's blended or traditional, is the personal assets. Who gets the, great grand's china set, or who gets that favorite clock on the wall? There's these things can often be items that don't even have huge financial value, but they are definitely something you need to pay attention to. The things of financial value that can also cause very hard feelings is jewelry. You know, some families have some very valuable jewels, you know, that have been passed down through the generations, or mean a lot to one child more than another, but there's a lot of value. So these are things that have to be looked at and can cause some real fights in families, because unfortunately the worst can come out in people when money is involved. So let's take a look here. You know, what we're here to do is to help you see these things clearer. We're here to be the neutral third party to take a look at it along with you and make sure that things are going to be aligned with your needs. And this is what we start with. We start with taking a look at what are all your assets. So it's really part of what you would be doing with a financial plan as well, is just taking a look at what the assets are and what the debts are, what the tax liabilities. We'll get into that in a moment. That's a biggie, is how will the taxes be paid. And of course, the will is going to be the key part of all of this. So when we're taking a look at the balance sheet, we need to take a look as well as what is the amount of cash assets? What are the assets that are going to be tied up, and what will be available for things, particularly if it's a premature death, unexpected? And certainly everyone's familiar with the idea of life insurance paying out very quickly. Is that going to be sufficient for the tax needs or for the immediate needs of the family? Maybe there's still children in school or university. Is there going to be the money available for those needs? And again, is that will up to date? So these are some of the things that we would be going over with you. I mentioned earlier about the executor. This is something that you do need to review from time to time, and a good executor should be really local. You certainly don't really want to be looking to out of province. For one thing, different provinces have different legislation, but also it's just going to be very difficult if you have, say, your son or daughter living in another province, dealing with things long distance. That's going to be quite difficult. And be very careful with making sure that they, at the very least, are living in Canada. You do not want to have an executor living in another country. And it's very difficult for investment firms to be dealing with executors or trustees and such living in the US. It needs to be somebody as well that knows the family relationships and how to deal with them, that can make good tax decisions and balance the needs of, perhaps there's divergent interests in your heirs. And so that's where if you don't have a family member with all these traits, and you know, a lot of families don't, or you're concerned about the spouse of a family member whispering in the ear, then that's where your executor could turn to their lawyer to help. Certainly you can name a lawyer as your executor. You'd need to speak to your lawyer about that. You can also look to professionals like a trust company as well. And certainly we have trust services that can help with that. But although there's a cost to a professional executor like a lawyer or a trust company, you need to balance that off with the fact that an inexperienced executor who is very busy in their own business or career, there could be a cost to the inefficiencies of that executor as well, or the missteps from a tax perspective, or the delays to the rest of the beneficiaries if the executor makes estate mistakes when they're applying for probate. Personally, myself, in my own situation, when I was executor for my mother's estate, I turned to my lawyer to apply for probate, because applying for probate is a very big process, And if you don't get the paperwork in correctly, the court's going to reject it and you're going to have to start again. And those delays could be very frustrating for everyone involved. So it's something that you can't just assume is going to be easily handled by a family member. Another concern for many families is their son or daughter, family member that they're considering is very busy in their career or with their own children or something. So you need to give some thought as to whether they would actually have the time or interest in being able to take on that role, because it is a big job. So let's take a look at tax. Certainly estate taxes are something that everyone has a lot of fears about. And Canada is very different to the US. So if you've been watching a US television program or reading US information about estate taxes, it's very different here in Canada. And we don't have in BC an estate tax per se, but what we do have is a very big tax liability on your RSPs and RIFs, because if you have named your spouse as a beneficiary or they've named you as a beneficiary, but there's now only one of you left, and you've maybe named the children as a beneficiary or just your estate in general, 100% of that amount is going to be taxed upon your death. So needless to say, it's going to go into a pretty high tax bracket. You know, we certainly have seen very common estates with $500,000 in a RIF goes into pretty close to the 50% tax bracket. So you're looking at a tax bill of, you know, $200,000, which, you know, not that that's necessarily wrong, but it's something that can be planned for and something your family also needs to be aware of, that there's going to be this tax bill. Capital gains is another one, and you know, many people have non-registered assets, and those can be investment assets, like stocks that they've held for 20, 30 years that have got a large capital gain, but it can also be a second property. Maybe you've got a cottage at the lake or you've got a rental property or something. You're going to be faced with capital gains tax on that, unless of course it's still joint with your spouse. But we're mainly talking about the tax liability when both spouses have passed away. So this can, you know, have a very big impact on the overall estate. And this is just a brief visual of how that works. So the RSPs and RIFs on the second death are 100%. 50% of the capital gain. So if you purchase something for 100,000, it's now worth 200,000. The capital gain is 100,000. 50% of that, so $50,000, would be added into your taxable income for that year. And then, of course, rental properties get into recapture of capital cost allowance and such. So definitely, this is where we find, particularly in blended families, but even in a traditional household, you have to be careful about deciding, well, I'm going to name Susie as my beneficiary on my RIF, but I'm going to say that John gets my house proceeds. And that's, you know, from the principal residence. Well, your principal residence doesn't have any tax because it's tax sheltered, but your RIF is going to be taxed at 100%. So even if those were, say, worth 500,000 each, it's a very unequal distribution. So have to be really careful about how you work those kind of beneficiary designations. And now we get into some of the complications of a blended family. So as we've seen with an RSP or RIF, if you have a spouse, from a tax perspective, it makes perfect sense to name your spouse as your beneficiary. But maybe that's your main asset. And maybe that's going to not really align with how you want to leave things to help your children. So which is going to be the more important concern? Saving the tax or leaving the money to your children. Now, if you're leaving the money to your children, they're going to get significantly less of it than your spouse is. And there's no easy answer to some of these questions. And this is why everybody's situation is different. But it's definitely a point that you have to weigh very carefully. And so just looking at that again, with a spouse, you can transfer all the registered investments tax-free. And certainly if it's an investment that you've held for a lot of years with that spouse, and there's an embedded capital gain, when you pass away, if it's in joint names, you can transfer to your spouse, and there isn't a tax bill on those capital gains yet until they pass away. But it's on that spouse's death that there's going to be the tax bill. So it is a balancing act, as we can see here. So, you know, one of the things that we look to do in what we're helping clients with is how can we protect these assets and put together an asset protection strategy. And certainly some of these strategies are strategies that we're going to spend more time on in subsequent webinars or videos, but we'll touch on some of them briefly here. So ultimately, you're wanting to transfer the maximum amount you're allowed by law to the beneficiaries of your choice. You need to make sure there's going to be liquidity to pay taxes. And then you want to, I'm sure, maintain the lifestyle of your spouse or your dependent children. So how do we do these things? And then when you throw into the mix maybe some family members that are challenging or adversarial, it can make it even more complicated. So some of the solutions we're typically using with clients are life insurance products, and those don't have to be a traditional life insurance policy. The life insurance industry offers the equivalent of a GIC, but you can name a beneficiary. You can also have the equivalent of a mutual fund with a beneficiary designation, and that's called a segregated fund. And then some clients choose things for guaranteed income like an insured annuity. So we're not talking necessarily traditional life insurance, although that can be a solution, particularly to a tax bill on a RIF. But sometimes an old policy that you already have can be repurposed, and you'll need to pay attention to who the beneficiaries on those old policies are. Another solution that we'll look at again in more depth in future is trusts. And we certainly see this as being a common issue for families where maybe there's some mental illness or physical disability. A trust can be a really good solution, and that can be a trust that comes into effect in your will. And then, of course, you have the important decisions of trustees and such. But some families, too, in order to simplify the estate settlement process, they look at creating a trust while they're alive, an alter ego trust. So again, trust can be a solution, but we'll have to take a lot more time in another webinar for that. So where do we start? You're at the middle with your family, and we're around the circle, putting our hands around you. As you can see from the things that I've touched on, the estate planning's really integrated with your financial planning, because ultimately your financial assets need to provide for your needs in retirement. And definitely the choices that are made will have an impact on your estate planning. And then the tax planning. Certainly we're all wanting to be efficient with the taxes now while we're alive, but we'll need to take a look at how that impacts the tax on your death as well. And then insurance needs and things. So there's a lot of issues that we need to examine and are really very integrated. This is a bit of a a typical path that one would take when they're looking at their estate planning. As I mentioned earlier, the first thing is to get a handle on where are you at right now? What are your assets? What do you have? And then we can take a look at the overall situation. We can look at optimizing some tax strategies leading into the estate planning, and then making sure that those things are going to honor your wishes. And then, of course, philanthropy or professional services of a lawyer or a trust in settling an estate might be something that needs to be looked at. The insurance needs, and then looking at all the strategic uses for that. So I've gone through a lot of things quite quickly today, and now I'm going to open it up for questions. So I see here that we have some questions posed already. One of our viewers is asking, what does probate cost? Right, so I alluded to probate, and certainly every province again is different here. And in BC, it's about 1.4%. So it's not huge, but it is a time-consuming process. It can delay settlement of estate by months. Probably the quickest it's going to be is 2 or 3 months, but can easily be longer than that. Potentially quite long if an estate is being contested by someone as well. But 1.4% is what the actual cost of assets, and that's for any assets that aren't in an RSP, RIF, or TFSA, or your joint assets that are named jointly with your spouse. So hope that sort of fills that in. Okay, and another question is a blended family question. So this is something we certainly see from time to time, is a family member that's, I guess, a quote unquote black sheep. Can you cut them out of the will? Well, in BC, we have something called the Wills Variation Act. And what that means is that anybody who feels they've been poorly treated by the will can challenge it. And your lawyer certainly could give you more information on this, but in a nutshell, what it is that the beneficiaries of the will would then need to defend themselves as to why that black sheep, perhaps, that was cut out doesn't have a legitimate concern. And this would then cause delays and expenses because it would have to go to court and such. So oftentimes, if someone is serious about doing an unequal distribution of their estate, we should be looking at things that are going to bypass the will. So if the will splits evenly, but there's not really much to split, and the other assets are flowing outside in an insurance policy or a trust, we could achieve the same end result that you're looking for, but without worrying about the challenge of the will. So Annette's liking the points on the RIF and house proceeds. Thank you, Annette. And then we have a question about different provinces. Yes, so if you do move from another province, in this case, the person's asking about Ontario, every province, as I say, does have different rules. So that's one very good reason to take your will to your lawyer and just see if there needs to be changes made to it because you're now living in BC. So definitely a move between provinces is a really good reason to just take it out and have a look, and even take it into the lawyer for a review. And just one thing I will briefly mention too, when you're looking for a lawyer, making sure that you're finding a lawyer that is very experienced in dealing with estates. Some lawyers are more focused on commercial law or perhaps real estate. And if you have a blended family, you want to ensure that you're dealing with a lawyer that has seen the ramifications of a a poorly done estate plan, or how much better things work with a very well-written estate plan. So definitely blended families should not be looking for the cheapest option when it comes to their estate planning. Now, was there any other questions? Okay, then what we're going to move on to is your homework. So this is the next steps that you need to take. You need to gather your information, and we do have a tool that can help you with that. It's called The Importance of Informing Others, and it's a really good tool to fill in for your own use, but also to then have set aside for your executor to make their job easier. And that tool is available on our website, and I'll show you where that can be found in a moment. You need to estimate your tax and your probate fees, and we can certainly help with that, as can your accountant, but we can give you some initial help before you even see your accountant on that, in taking a look particularly on your RSP or RIF, what would be that tax liability, because that's the biggie right there. Now, the big area that you need to give some thought to is your goals and what's important to you. What are the core values and things that mean a lot to you? Do you have particular concerns about, in addition to your family, obviously, your community, your faith, maybe your protection of animals, world issues? Is there things that you want to be remembered for? Helping your family, supporting your community? Is there life accomplishments or aspirations that are on your bucket list, or things that you want to have memorialized? Do you have some thoughts on which of your possessions might be meaningful or important to family? Perhaps you should ask them, give some thought to that. Another non-financial thing that I like to bring up to people is, do you have a legacy of memories you want to pass down, or messages to leave to people? I think these are some very valuable things that your family would really appreciate, and something that is not tangible, but would be a very important thing to give some thought to. And so then, whoops, went by too fast there. So explore these, put some thoughts down in writing, and plan then how we need to put a plan together as how to integrate all these things. The other really important area is that in-between stage between now and death is the time of incapacity. And again, that's a whole nother workshop on dealing with powers of attorney and health representation agreements, but this is definitely something that's really important as well. And who do you want handling your affairs if you're not able to? And then, of course, consulting the professionals, and then pulling it back out again, as I mentioned, every 3 to 5 years, and making sure that it's still in alignment with what you want. So I'm just going to stop sharing my screen, and now let me just see if I can bring up our website where we have a lot of resources, and put that up on the screen. Okay, so here we go. So I'm going to lead you through to where you can find some resources for your estate planning. So I've brought up our website, and under the button, How Can We Help? You can see here we've got a lot of different categories, and one of them is estate planning. So under here we have estate planning resources. We've got the estate planning guide for BC, and then this is the document I was telling you about, the importance of informing others of your intentions, how to choose an executor, And then if you're named as an executor, what are your duties? And then an executor duty checklist. Another one that we're going to be adding to here is an estate planning checklist as well. So between the estate planning checklist and the importance of informing others of your intentions, you'll be able to get a good start on your estate plan. And so now I'm going to stop sharing, and I'm just going to speak to you directly for a moment that some of you, listening to this right now are really motivated, and I can make a very accurate prediction that for each of you, one of two actions are going to occur. Some of you are going to swing into action and you're going to download those resources and you're going to get started and you're going to pull out your existing will and review it. But there's probably quite a few who are going to think, well, this is really something I should do and I better do that one of these days. And I'll get around to that eventually. So maybe you don't want to face the facts, or maybe there's some other things that are more pressing. And oftentimes it can be, oh, I'm just not sure what I want to do. But if you want to be sure that number 2 doesn't happen, and you want to make sure that you're part of that first group that swings into action, do feel free to use us and send us a message that you'd like to go over these things with us, or you'd like to be accountable to us about it. And we're certainly happy to help. We're also happy to help go through the checklist with you or the informing others of your intentions document. So with that, I'd like to thank my behind the scenes team, Annette and Rachel. Thank you for helping us put on this successful event. And thank you so much for attending this. And as I mentioned earlier, if you'd like to share it with a friend or family member that you think would benefit, please feel free to share that link. And so thank you so much for attending, and we look forward to presenting another one of our webinar series to you next time. Thank you.